The Department of Homeland Security is proposing to change the current public charge rule. In today's video, we're going to talk about the top 5 key changes that the Department of Homeland Security proposed to make. Right now, the public charge rule is only in its proposal stages. At the moment, nothing is changing, but the Department of Homeland Security gave the public 30 days to make comments before they are able to officially finalize and implement it. So this rule is expected to go into effect in the early months of 2026. So let's quickly review who is considered a public charge. If you are new to the entire adjustment of status process, you may not really know what it is and how it may apply in your case. The basic definition of someone who is a public charge is somebody who heavily relies on government assistance to survive. Before an immigration officer is able to approve your green card, they look at a lot of different criteria to decide if you are eligible. And one of those criteria is whether you are likely to become reliant on government assistance. But not every green card applicant falls under this rule. Some green card applicants, such as asylees or refugees or some special categories, are actually exempt from this rule. So they can be approved for a green card considering they met all other criteria, even if they received government assistance in the past or if they will do that in the future. And you can see the list of these exempt categories on the USCIS site policy manual, in the Federal Register, and also in the Form I-485 in Part 9. But most green card applicants through family petitions, employment petitions, and diversity processes do fall under the public charge rule, which means that an immigration officer must first examine whether you are likely to become a public charge, whether you're likely to rely on government assistance. On November 19th of 2025, the Department of Homeland Security published a newly proposed public charge rule in their Federal Register that would apply to adjustment of status applicants. Earlier this year, we also talked about a USCIS policy memo that encouraged immigration officers to use their discretion when making decisions about someone's eligibility for any kind of immigration benefit. Basically, what that memo meant is that immigration officers were allowed to use factors that are more broad, more subjective on case-by-case basis in order to approve or deny someone. Now, subjectifying a process may work in someone's favor and may work completely against someone else, depending on who is reviewing their case, depending on what state the applicant is located in, and depending on how an immigration officer views certain facts of someone's case. So let's talk about these top 5 changes that DHS is proposing to make. Number 1, DHS is broadening the list of factors that an immigration officer can consider when making a decision about someone's case. At a minimum, this rule will require immigration officers to review an applicant's age, health, family resources, finances, assets, education, and skills. And these factors have been included in the public charge rule since the 1980s. However, it is no longer going to be a very clear-cut definition of checking off boxes. If somebody meets all of the criteria based on their age, health, financial status, household size, the immigration officers will now be given a free rein to use their discretion to decide how to interpret these factors. Number 2, DHS is expanding the list of public benefits that will now be considered in the public charge determination. The 2022 public charge rule, which is the rule we're following at this moment, only considered the receipt of 2 main types of public benefits as making someone ineligible. These 2 types of benefits were either receiving cash assistance such as SSI SSI, TANF, and also local cash assistance programs. And the second type was being institutionalized at a government expense for a significant amount of time. Now, this newly proposed rule will include the receipt of any and all public benefits in the list of public charge determination. DHS states the reasoning behind this is that not receiving cash benefits or being institutionalized is not enough to prove that someone will not rely on government assistance. In their proposed rule, they're stating that the cost of applicants and their households, their families, receiving things like food stamps, Medicaid, housing, puts a very heavy burden on the government, which is one of the reasons why they're trying to expand the list of public benefits that will be included in the public charge rule. Number 3, DHS is also removing the time-bound period of receiving public assistance in order to make a public charge determination. If an applicant received any public benefits at any time in the past, will be counted negatively towards this public charge eligibility. They are also going to consider your application for public benefits in the past, not just their receipt. So basically what they're trying to say is that if you were in a situation where you simply sent in an application, even if you were not approved, even if you never really received any benefits, that still will be counted negatively towards this public charge eligibility. Number 4, if you have ever received public benefits in an exempt category that we mentioned in the beginning of this video, it will now be still negatively counted against you. Now, in the 2022 rule, the receipt of public benefits in a category that was exempt from the public charge rule did not make somebody ineligible when they are applying for a green card in a non-exempt category. So for example, someone who used to receive benefits when they were an asylee, now applying for a green card through marriage, for example, the receipt of those public benefits in the past didn't really count against them because they were in a immigrant category that was exempt from this rule. However, DHS is proposing in this new rule that it no longer matters if you were in an exempt category. Because you're now applying in a non-exempt category, your past receipt of any public benefits, regardless of what status you held, will be also counted negatively against your public charge eligibility. And number 5, the affidavit of support will no longer be sufficient to satisfy the public charge requirement. In the current rule, USCIS considers the affidavit of support as an overwhelmingly positive factor that would weigh against all other factors in the public charge eligibility. DHS in this new rule states that the mere existence of the affidavit of support in your case doesn't really guarantee that the applicant will not apply and receive public benefits in the future. They're saying that the affidavit of support simply guarantees that the sponsor will repay the US government for any public benefits that were received by the applicant, but payment of these public benefits is no longer enough to prove that someone is not a public charge. Their main objective in this new rule is to deter people from applying and receiving public assistance in the first place. And the final 2 key takeaways. Although this new rule does not explicitly state that the receipt of public benefits by the applicant's household members will be considered, receipt of public benefits by household members was indeed heavily considered in 2019 public charge rule. During that time, applicants had to fill out the form I-944, which I personally also had to fill out. In that form, you had to indicate all the household members that reside with you, and if they receive any benefit. Now, DHS in this proposed rule did not explicitly mention if they're going to consider that, but it seems that it might be leaning that way, and we will only be able to find out after they publish the final rule and make changes to the form I-485 questions, as well as clarifying what they mean in the form instructions. And the final takeaway from all of this is that the burden of proof always lies on the applicant. This doesn't just apply to the public charge rule, but it applies to any other immigration benefit applications you as an applicant are responsible for to provide as much evidence as possible of how you qualify for an immigration benefit. When it comes to public charge, what I foresee happening going forward is applicants will be asked to provide extensive evidence of how they qualify for a green card and how they can prove that they're not going to become a public charge. Now, currently, applicants are not required to initially provide evidence for each of those questions that they're answering in regards to public charge. But what I think would be a good idea moving forward, or possibly this would be included in the future form instructions to this form, is for applicants to indeed begin including this evidence with their application ahead of time to give USCIS officers a better idea, a better picture of you as an applicant and how you qualify for a green card. So I hope that you found this video useful. Let me know what you think. I hope that I was able to explain to you guys in simpler terms of what this newly proposed rule actually means. Give this video a thumbs up so more people can see it. Subscribe to my channel if you haven't already, and I hope to see you guys in my next videos. Bye!